Ever had that moment in school where a massive assignment is due, you haven't done any of the work, and the clock starts ticking down? You start coming up with the wildest excuses you can think of to buy some time. A few days ago, in a Washington, D.C. federal court, a high-stakes legal team used this exact strategy to avoid a looming deadline. A federal judge set a firm deadline for the legal team protecting Donald Trump's past. They were ordered to hand over a massive cache of files that have been kept out of the public eye. These are not routine documents. We are talking about millions of files directly related to the Epstein Transparency Act. Instead of handing over the files as ordered, the Department of Justice showed up literally minutes before the deadline with a list of schoolyard-style excuses to stall the release. The first maneuver is the stalling tactic. The absolute final deadline for this massive assignment was July 2nd. The legal team waited until there were just minutes left on the clock to hit the judge with an emergency motion. They didn't hand in the work. Instead, they asked the judge for a 60-day extension. Their stated reason was that they needed 2 full months just to decide whether or not they wanted to appeal the judge's original ruling. This brings us to their second excuse, which requires a look at this diagram. On the left is what the judge actually asked for, a redaction log. Think of it like a highly detailed grocery receipt. If the government wants to hide a document, they have to list it out line by line and give a specific legal reason for keeping that specific file secret. On the right is what the lawyers actually handed in. They refused to make the itemized list. Instead, they slapped down the equivalent of a sticky note, offering a short summary that claimed blanket protections over everything, using broad terms like executive privilege. Without that itemized receipt, the court and the public are completely in the dark. There is no way to verify if these documents are legitimately protected by law or if they are simply being hidden because they contain embarrassing truths. The third excuse involves the identity of people mentioned in the files. The Department of Justice refused to uncover certain names, claiming they are required to protect the identities of the victims. The lawyers argue that 3 of the 4 names listed under co-conspirator headings actually belong to individuals who are victims. By reclassifying these suspects as victims, the government can keep their identities redacted and out of public view. The legal team had already leaked the names of actual victims, but they are now using this victim status argument to shield individuals originally flagged as co-conspirators. The fourth tactic is the rough draft. The legal team is refusing to hand over the original handwritten notes taken by investigators. Their justification is that the handwritten notes are duplicative of the final typed reports. They are essentially telling the judge to ignore the rough drafts and just trust the final typed versions. In any investigation, the original notes are crucial evidence. By hiding them, accountability vanishes. There's no way to verify if those final typed reports were edited or sanitized before they reached the judge. Why would a massive legal team, backed by thousands of government lawyers, resort to a string of desperate, childish excuses? It all comes down to a deliberate manipulation of the rules citizens use to request government documents. Look at this shell game. When journalists previously tried to use standard Freedom of Information Act requests, often called FOIA, to get these files, the government rejected them. The lawyers pointed to a different shell, telling reporters they had to request them under the Epstein Transparency Act instead. But it was a trap. Now that a reporter is actually suing them under the Transparency Act, the lawyers are telling the federal judge that reporters have no legal right to sue under that act. They are demanding the reporter go back and use FOIA. They are sending reporters in a circle. And the lawyers even admit in their own court filing that the public would get far less information under FOIA. Their clear motive is to keep these records buried. These procedural maneuvers are organized within the United States Department of Justice, utilizing the same legal system that is supposed to ensure transparency. The recurring use of these excuses, combined with the complex jargon like deliberative process privilege, creates a persistent barrier. It keeps the most sensitive files regarding Donald Trump's associations out of the hands of the public. Share this video to expose these legal tricks. And make sure to subscribe for more deep dives that cut through the smoke and mirrors.